to our fourth and longest class. This is going to be perhaps close to an hour. This is American constitutional law. Don't take this as a be-all, end-all American constitutional law class. This is as good as I could make it with the knowledge that I have. I believe it's good enough. I'm going to go, because the American Constitution is so short, we have the ability to go like article by article, amendment by amendment, and explain each one of them. The reason you have to do that is the American Constitution is, I think, something that comes up quite frequently in litigation. Obviously not so much in commercial litigation, but you know, it influenced us a lot. And really, it was really the first of its kind. There were constitutions before that, but you know, this one really introduced us to the notion of what a constitution should be. So as a lawyer, I think, you know, we should be familiar with it. If you're a criminal defense attorney in particular, the Constitution is going to be very important, because most litigation concerning criminal matters has to do with the Constitution. The Constitution is, in particular, the Bill of Rights has a lot of provisions about criminal procedure, and if you're a criminal defense attorney, you have to understand those. So let's get started. Right, so the American Constitution, the current one, is from 1787. So 1787, and not so it's 11 years after independence, right? So the Declaration of Independence was signed in 1776, and from that period, for those 10 years, there was a different document called the Articles of Confederation. And you could see it as America's first constitution, but it's a bit difficult to call it a constitution. It was more a treaty almost, because the confederation that was created was so loose. The government, the centralized government, didn't even really have the power to enforce the laws that the Congress approved. So it was really an experiment, and it did not go well, which is why they had to make an actual constitution with a centralized federal government that had more powers, because the first attempt with the Articles of Confederation was not successful. So the Articles of Confederation, they're not binding law anymore. They have no legal value, but it's funny to still see some people quoting them sometimes. But really, of all these documents, the only one that is binding law in America today is obviously the U.S. Constitution, which is the supreme law of the land. But the Federalist Papers is also something that you're going to see quite often if you read American case law, because, like I said, it's not as common for American judges to quote philosophical ideas in their decisions. When they do, it usually comes from historical sources, such as the Federalist Papers, especially because in America today, the dominant way of constitutional interpretation today is something called originalism. So they always try to strive for the original meaning of the constitutional norms. And if you're looking for the original meaning of the Bill of Rights and the original provisions of the Constitution, the Federalist Papers are a very good source of. So what the Federalist Papers are is there are a number of letters and articles written by some of the founding fathers, in particular Thomas Jefferson, some others, I can't quite remember so Thomas Jefferson and other founding fathers to each other, you know, correspondence and letters. Correspondence and letters that they sent to each other, where they explain what they think a government should be. So there are detailed ideas of what they think the government should look like, what the government should do. And this is interesting, and it's still a very good source of political theory today, where we can read. This is basically what created this idea, you know, because people were talking about, you know, different branches of government before, but the current understanding, you know, judicial, legislative, and an executive branch really does come from the Federalist Papers. You know, we had Montesquieu had written had written about the subject before, but this is really flashed out, and really the way we understand it today comes more so from the Federalist Papers than other sources from that time period. Right, well, like I said, the only one that's legally binding today is the Constitution, although you can look to the others for some meaning and some help in interpreting the Constitution, in particular the Federalist Papers. Right, so the original draft, it refers to the articles of the Constitution that are not amendments. It's a very short document. It did a few things. It created the Supreme Court, which is the only court that the Constitution institutes. So all the other courts in America were created by statutory provisions, so laws approved by Congress. Also, you know, have courts at the state level, which are not regulated by the federal government. And they created this bicameral legislative branch. So that means the Senate and the House of Representatives. This was modeled off Britain, but in America it has a different meaning. In Britain, originally, it was supposed to refer to the interests of commoners and the interests of the members of peerage. Today, the House of Lords in the UK does not have a lot of influence. We analyzed that last class during our analysis of English constitutional history. But in the United States, the Senate does have a lot of influence, right? So it's the upper chamber, and all bills and all acts of Congress have to go through both houses, right? There are a few differences in what the both two houses do. For instance, budget bills, they originate in the House of Representatives. Impeachment originates in the House of Representatives. But if you're trying to confirm, for instance, nominees for the Supreme Court, you do it through the Senate. And when you do an impeachment trial, the articles of impeachment are approved in the House of Representatives, but the impeachment trial itself takes place in the Senate, and it's the Senate that decides to convict or acquit the person being impeached, which has to be a federal official. Executive power is established in the person of the president, who is the commander-in-chief, right? So he's the supreme commander of the armed forces, and he has to approve all bills. He has veto power over bills. The veto can be overridden by Congress, but if it's not, then it has to be approved by the president. But the president does not have any influence in the process of amending the Constitution. He only does when you're passing through normal legislation. Right. Before we get into the document itself, we have to talk about standards of review. When you want to say that something, an act by Congress or by a state government, by some official, or a bill is unconstitutional, you have to say based on what standard of review. So there's 3 standards of review. You have mere rationality, strict scrutiny, and the intermediate level of review. And what it means basically is mere rationality would be, is there a legitimate government purpose and is this connected to that purpose? So this is the weakest standard of review. And the intermediate would be somewhere in the middle. So obviously middle level review. So it's an important and substantial, important objective from the government. And the ways of accomplishing that objective have to be substantially related to that goal, right? So as you can see, these are very broad terms, which is very common in the common law system. This is going to be up to the judge to determine if these things are present or not. And then you have strict scrutiny. When you're looking at something, for instance, a criminal statute, you have to look at things, for instance, if it's necessary or if it's rational. If you apply strict scrutiny, is it necessary? Meaning, is there no other way of accomplishing this government objective that isn't this one bill, which is can be maybe considered very restrictive, or maybe it's too invasive? So those are the three standards of review. And when you're arguing that a bill or something is unconstitutional before court, you have to specify based on what standard of review. So now we get into the document itself. So Article 1 of the United States Constitution institutes Congress and divides it into the Senate and the House of Representatives. Originally, the senators were not elected. They were appointed by state legislators, right? So the individual House of Representatives and Senates in the states would appoint senators, but this was changed by the 17th Amendment, and now they're elected, right? They have a longer term in Congress. It's a 6-year term, and there's 2 senators per state. So it's 50 states, 100 senators in total. Also, this is something that maybe is not worth getting into too much. The Constitution also speaks of ensuring a republican form of government for all states. So all states have their own legislatures, and in 49 states, the state legislature itself is divided into a state senate and a state chamber, except Nebraska. Nebraska only has 1 chamber, which is like what we have here, right? But in America, even small states, like you think Rhode Island have a state senate, which is a bit funny to us. Also, emoluments. Emoluments means receiving a gift, right? So if a foreign official, such as a prince or president, gives a public official a gift of substantial value, that gift has to be approved by Congress in order to not constitute corruption. The bills of attainder, what they are basically is you would go through Congress and you just pass a bill saying, I want this person to be convicted. So instead of going through a proper trial, you just say, this person now is a criminal, and that is a bill of attainder, and that is unconstitutional. Also, the writ of habeas corpus, extremely important, is guaranteed, and the prohibition of titles of nobility, right? No titles of nobility can be established by any state or by the federal government. You cannot have, dukes. If an individual state wants to create some sort of peerage system, they're not allowed to. And this is something that it's very interesting. It hasn't really been tested in the courts too much. Some people tried to test this when it comes to state universities in the United States having legacy admissions. Some people have argued that constitutes a sort of title of nobility, but it has never really been tested in the courts. I think it would be very interesting to see what they say. Also, when it comes to foreign policy, so states and state governments are not really allowed to negotiate foreign policy. This is something that is exclusive to the federal government and to the president in particular. This is establishes the offices and powers of the president. Also, impeachment. Impeachment on the grounds of treason, bribery, or other high crimes and misdemeanors. As you can see, this is very broad. This can be basically anything. And, the understanding today is that this is a political matter and not really a legal matter. So you can really impeach a federal official, which doesn't have to just be the president. You can impeach any federal official, including judges or justices. And you can really impeach them for many things. It's more of a political thing. So you had in the 90s, President Clinton was impeached for perjury, he was having an affair, and the impeachment, the articles of impeachment alleged that he had lied before Congress. So he had committed perjury, and there was an attempt to remove him from office, so he was impeached. So even if the person isn't convicted, you still say that they've been impeached, right? So in order for a person to be impeached, all that has to happen is for the House of Representatives to approve the articles of impeachment. Right. So the judicial power, which is vested in one Supreme Court. So like I said, this is the only court that exists in the United States by the Constitution. All the other courts that exist have been established by law, be it state law or federal law. And they have appellate jurisdiction in all matters and also original jurisdictions, right? So if there's a litigation between two states, and this happens a lot. For instance, New Jersey sued New York for some border issues. They wanted to determine where the limits of their borders were, so this went up in the Supreme Court. So they have original jurisdiction in some matters, which is similar to the original jurisdiction we have in our Supreme Court here. Original jurisdiction just meaning that there's no lower court that analyzes it. It goes straight to the Supreme Court. The appellate jurisdiction can be done from any court in the country. When you want to access the Supreme Court, you file something called a writ of certiorari. I'm not sure that's how it's pronounced. And basically the Supreme Court can decide to hear that case based on that writ or not. And it's completely up to their discretion, and they don't have to tell you why they didn't want to hear your case. It prescribes how the relationship among the states shall take place. So like I said, a republican form of government, so no state monarchies. Also, this is important because the territory and the representation in the Senate belonging to the states and in Congress in general is something that cannot really be altered even by the means of a constitutional amendment, right? So you cannot subtract senators from a state by a constitutional amendment. This is one of the few things that you cannot change with the constitutional amendment in the United States. There's a whole procedure for states to be admitted into the Union. This hasn't happened in a long time. The last time new states were admitted into the Union was in the 50s. You had Alaska and Hawaii. But there's a lot of talk today of admitting new states such as Washington, D.C., the District of Columbia, or Puerto Rico, or any other territory. Because the United States, in addition to having states, also has a lot of territories. So you have the places like the Mariana Islands, the Virgin Islands, and American Samoa. So in those places, the Constitution is still in effect, but there are some limitations, right? So if you're from Guam, for instance, which is a U.S. territory, you cannot vote for president. So even though it's part of the U.S., the territory of the United States, and there's people living there, you cannot vote for president. So those places usually send a non-voting representative to the House of Representatives. So you have one for D.C. and one for Guam. They have the right to speak, but they don't have the right to vote, right? Some people dispute that, especially in the case of the District of Columbia, because it's home to about 1 million people, so it's a lot of people. A lot of people dispute that on the grounds of being taxation without representation, right? Which was one of the reasons for the American Revolution. So this is a very intense political topic in the United States, whether or not some existing territories now should be admitted as new states. But there is a procedure to do that, and it's prescribed in Article 4 of the American Constitution. So amending the Constitution of the United States, as per Article 5, is extremely difficult. You need two-thirds of both houses of Congress, and this is what really makes it difficult. All the state legislatures also have to approve. I think it's more than 2/3. I have to check. Você pode pausar por segundo? Deixa eu ver uma coisa aqui. Acho que é meu celular. Depois você corta, né?
Você fala os arquivos, fica difícil sincronizar a obra depois.
Ah, tá. Pode cortar. Eu quero ver se tá certo. Eu acho que eu escrevi isso aqui eu mesmo. Tá bom até agora? Tava bem na câmera?
Eu mexi aquela hora, Lucas, só porque alguns momentos estavam indo um pouquinho mais para a direita, e daí por isso que eu virei um pouquinho.
Ah, eu tinha falado errado mesmo. Vamos refazer. Alright. So, tá indo, né? So Article 5 of the Constitution, it says out the procedure for amending the Constitution, and this is extremely challenging. This is very difficult, which is why it's done so infrequently, right, compared to our. There's two ways to do it. One of them is to have 2/3 of both houses of Congress to agree on it, or to have 2/3 of state legislatures call for a constitutional convention, right? The second way has never been done. All amendments have been passed by two-thirds of the houses of Congress. But either way, you need 3/4 of all state legislatures to approve the amendment, and this makes it really difficult to pass any amendments. Something that was an entrenched clause before 1808 was the issue of slavery, which is mentioned in the Constitution. The Constitution said that slavery could not be abolished before 1808. It will only be abolished in 1863, as we'll see further ahead. But anyway, it's extremely difficult, as you can tell. So any political change is not going to have probably approval of 2/3 of both houses of Congress and 3/4 of legislatures. And you have to remember that most legislatures have 2 chambers, right? So there's so many people that have to approve of a constitutional amendment for it to pass that it very, very rarely happens. In the old days, of course, that happened more frequently. Today, there's a lot of division, and the Constitution is more well established, so there hasn't been an amendment, I think, the 80s, which was going to be the last amendment that we're going to analyze at the end of the lesson today. Article 6. This is important, and this was tested in the decision McCulloch versus Maryland and in Marbury versus Madison. The Constitution is the supreme law of the land, right? What made the American Constitution special, and one of the cases that you have to read is Marbury versus Madison, is the fact that any law or bill passed by Congress which is repugnant to the Constitution, so it goes against the Constitution, is void. And this is a new idea back then, that you could strike down something coming from Parliament. This is a very strange thing that didn't really exist. And that's why the decision Marbury versus Madison is one of the most important decisions ever, and that's why I picked it as one of the decisions that you have to, one of the Supreme Court decisions that all the students in this course have to read. So this is Article 7, just determines when the Constitution comes into effect. This is the end of what you call the original provisions. Then you come into the amendments, which is where most of the things we know about the American Constitution are, specifically the first 10 amendments, which are called the Bill of Rights. So looking into some case law, we have here Marbury versus Madison, which is one of the cases that you have to read. This in particular here, and I had to change the language a little bit because it's a very old decision. It was written in a way which is a bit hard to understand. It is a proportion too plain to be contested that the Constitution controls any legislative act repugnant to it. This is, like I said, very, very new idea. This basically created the concept of judicial review. Or that the legislation may alter the Constitution by an ordinary act. This doctrine would subvert the very foundation of all written constitutions. It would give the legislature a practical and real omnipotence. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principles that the law repugnant to the Constitution is void. Like I said, this is really revolutionary by the Supreme Court. Probably the thing about the American law that has most influenced every other system on earth. Also McCulloch versus Maryland, also an important case because it's established that all acts of Congress which were in accordance with the Constitution were above state law, right? So if there's a conflict between a state law and a law and a statute or a bill approved by the federal Congress, and that statute is constitutional, then that statute must prevail over the state law. So here you have it, the 6th Article of the Constitution of the United States declares that laws made in pursuance of it, so in pursuance of the American Constitution, so they have to be constitutional, are going to be above state law. This is also something relatively new, and it's something that comes up quite frequently, which is why it's very important to determine what the powers of Congress are and are not, because a lot of bills have been struck down on the grounds of Congress does not have the authority to regulate that, right? So that bill is unconstitutional and it cannot override state law. Right, so here's some relevant case law. I'm going to do this a lot during our course. Marbury versus Madison, obviously you're going to have to read that. McCullough versus Maryland, and the other things here being case law pertaining to the original provisions, right? So the first 7 articles, as we just saw, and now we get into the Bill of Rights, which is, I think, what most of you are familiar with. So the first 10 amendments of the Constitution, which were approved right after the Constitution was ratified, are called the Bill of Rights, and they contain a lot of fundamental rights, right? Because if you look at the original provisions, they don't have a lot of fundamental rights. There's some things like, habeas corpus, bill of attainder. This is also something that was quite interesting of the Constitution, to have these fundamental rights, not to just have a political system. So today we understand any constitution as needing to have fundamental rights in a political system, and this is really something that was introduced by the American Constitution. And the amendments after the first 10 amendments, they usually they deal with things that are a little bit more particular. The 13th and the 14th and also the 15th Amendment are very important. It's particularly the 14th Amendment. Almost every famous case coming out of the US was based on the 14th Amendment because it talked about due process and fair treatment. It was basically where the idea of equality under the law understood in the American Constitution, because it's not really present anywhere else. So when we talk about people being equal under the US Constitution, we usually talk about the 14th Amendment. It was also very important because it established that all the Bill of Rights applied to the states as well as to the federal government, with 2 exceptions. So you have the 7th Amendment does not apply to the states, so that's jury trials for civil cases, and also the grand jury clause of the 5th Amendment that does not apply to the states. They can have that if they want to, but they don't have to have that. I'll explain what those things are later as we study criminal and civil procedure. First Amendment, very, very famous. It establishes both freedom of speech and freedom of religion. It's important to say that it doesn't establish only the freedom of religion, but also the separation of church and state, right? So when you think about the lack of religious tests, the idea that you don't have to follow a particular religion and that the state cannot impose a religion upon the people, you're talking about the First Amendment. Also, the addition to the possibility to petition the government for the redress of grievances. This is important. It's something that also comes from English law. So under the First Amendment, the understanding that prevailed over the centuries, and this is a case from the 60s called Brandenburg versus Ohio, is that offensive language is constitutionally protected. So in America, this is very different from Brazil. It is constitutional to say racist things, right? So you can have different political opinions about this, but the Supreme Court has repeatedly upheld the validity of the idea that you can be racist and be protected by the Constitution. Another interesting thing that it protects is against vague language in the law, right? So if the law says it shall be illegal to, for instance, to be evil, obviously that's vague. It cannot be determined with precision. So we're going to analyze that when we study criminal law. But one limitation of free speech that does exist under the Constitution is illegal conduct. So you can be racist, but you cannot call for violence. So if you want to have a peaceful demonstration for a racist idea, that is protected by the Constitution. What isn't protected is obscene speech. It's basically saying that pornography and things like that can be limited by the law, or even forbidden, which has happened in the past. There used to be criminal statutes against pornography. Those things are not protected by the First Amendment. Also, it's important, this applies to the entire Constitution. It really only applies to the government. It doesn't apply to the relationship between individuals, private individuals. So if you're in a building or a business or even a social media platform, they have the right to restrict your ability to speak without violating the First Amendment. Commercial speech, so speech by corporations, and you saw this in the Citizens United decisions, they consider corporations to also have the right to free speech. Also the freedom of association, which is also understood as being part of the First Amendment. Religion and association. So basically you cannot be discriminated for your opinions, basically, because those are all parts of speech. So going over individual decisions which shape the idea of free speech in America. You have 2 very important decisions. One of them is Schenck versus United States. This one has been overruled, but it's still good to understand the original meaning. So it basically created the idea of a clear and present danger, which is not something that is enforced anymore. This was substituted, as we're going to see in the next slide, Basically, what happened here, this was 1918, so you had the First World War, and you had people who were opposed to the draft, right? So the draft was when you call soldiers to the war and they're forced to go to Europe. So they were against American involvement and they were against the draft. So there was this man was handing out pamphlets opposing the draft. The Supreme Court decided that constituted a clear and present danger. So the analogy they made was with a shouting fire in a crowded theater, right? If you cause a panic and people trample each other and people get hurt or die, then you can't claim free speech to evade liability, right? It's something that has to be connected to a threat. So it has to be a crowded theater. It has to cause a panic. So the context here was that there were a lot of theater fires in the early 1900s. So today, if you shouted fire in a movie theater, probably nothing would happen. You'd probably still be protected because today there's better fire protection, there's better building regulations, but back then it was a real concern. So they're basically saying you're not allowed to create this clear and present danger. But this was a bit too vague, it was not good enough, so it was substituted in the 1960s by this decision here, Brandenburg versus Ohio, which replaced the idea of clear and present danger with imminent lawlessness, right? So basically what it's saying is that you can say whatever you want as long as you don't advocate for illegal conduct, right? So this is like the plus. You can protest peacefully, but you cannot try to break into a building as a result of your protest or as a result of your ideology. So the speech part is always protected. It's the action part of the speech that can be restricted. So this is the standard that's used today when we're talking about limitations of free speech, right? Because no right under the American Constitution is unlimited. We're talking here also about libel. Libel basically means someone's spreading falsehoods about you and you sue them as a result. This is a decision that came to limit the government's ability to sue people for libel. So this was a number of cops who had sued the New York Times for libel in the context of the civil rights movement. And basically what they said, the Supreme Court said, is that for the government to win a libel case, and really libel cases in general, that there had to be more rigorous standards. So the standard that they used was actual malice. So you had to know that what you were saying was false, or with reckless disregard, and you just didn't care, right? So if you say something and you think it's right, but then it turns out to not be right later, you're protected from being sued for libel, especially by the government, right? Because the government suing you for speech, that's something that would obviously be a threat to free speech if it wasn't very restricted. So relevant case law, there's obviously all the case law that I show in these slides is not really definitive, or it doesn't even come close to being an exhaustive list. This is just really the most important cases. This is just a big list. If you read all of this, I think you'll gain a basic understanding of this particular matter. But if you want to really understand it and apply it to your own legal practice or to your own job, you have to read a lot more case law than this, right? So this doesn't even really cover most of it. It just covers the bare minimum. So the Second Amendment, this one is the same as in Brazil, really around the world. It has not actually been litigated too much. People might think that it has, but it only come before the Supreme Court a few times. Most recently in 2009, which was basically when they decided that it was actually protection of carrying firearms and not just of forming a militia. Because you can tell it starts with a well-regulated militia. So there was this idea that what the amendment was actually talking about was the ability to form the militia that was, so that being the National Guard of the individual states, which was formed by citizens. The Supreme Court basically said, no, that's not all, that's a part of it, but also there's a right to actually bear a firearm for personal protection. It happened in the District of Columbia versus Heller case, and before that, there was the militia part was more emphasized, but now it's really understood as something that protects the right to bear arms, literally, being actual firearms. So the decision itself only handled handguns. But people always claim it when they want to have the right to carry rifles. So it's a very hot topic issue in the United States. But there's the most recent case law on this matter, or the most relevant case law, recent case law, was in 2009. And if it went before the Supreme Court today, it would probably not change. If anything, it would probably only expand the right to bear arms, because there's a very conservative court in DC today. Right. So this is from the decision itself. So there was a handgun ban in handgun ban in the District of Columbia. That was the context in which this litigation was brought before the court, and they said that's unconstitutional, that cannot stand. Relevant case law here, McDonald versus City of Chicago, U.S. versus Miller, overruled by District of Columbia versus Heller, but still interesting if you want to read what the previous opinion was before District of Columbia versus Heller. Third Amendment, this is the amendment that's been litigated the least when we talk about the Bill of Rights, so that's the first 10 amendments. This amendment has only really been heard before the court once. We're going to see which case it was. But basically it says that soldiers cannot be quartered in your home during time of peace, and in time of war there has to be a law, prescribing the actual procedure, for having soldiers in your home. This is not something that really has ever been a big threat after the Revolutionary War. During the Revolutionary War, there was an issue, and there are reports of this being an issue during the Civil War, even though no one ever really brought the case to court. There's reports of soldiers just going into people's homes, even in the territory controlled by the Union. But it's an amendment that's almost been forgotten. But it's still there. It's still in place. It's still a protection that you can invoke in any court. It's been incorporated into the states by the 14th Amendment. So if there's anything like that happens to you in the United States, you would have that protection from the Constitution. So the only relevant case, Evoluiu versus Carey, was about the National Guard, not about the military itself. So the National Guard is basically a little military that is under the command of the state government. And the Supreme Court decided, that is actually a form of soldiers. Those are military soldiers. They are limited by the Third Amendment. But it's also been used to justify the idea of there being a constitutional right to privacy. So if you read the decision in Griswold versus Connecticut, they do mention the Third Amendment, and that is one of the cases that you have to read in the course. Basically, Evoluiu versus Carey, it was these correction officers, that means these police officers who worked in a prison, and they were giving these apartments to live in, which were right next to the prison, and they were striking. The government vacated their apartments in the apartments that they provided for the correction officers, and put National Guardsmen in the apartments. So they were basically saying, well, this is a Third Amendment violation because National Guardsmen are soldiers and they cannot be lodged in my home during a time of peace. The Supreme Court said they weren't because the government provided housing would not be your own home. So if you want to read the whole decision, it's more of a curiosity because it's not very relevant, but it's an interesting read. And it didn't really reach the Supreme Court. I'm sorry, it stopped at the Court of Appeals, but it's still binding precedent. So the Fourth Amendment, very, very important. It's the amendment that protects your right to be secure against search and seizures, right? So when you hear people in movies say, "Do you have a warrant?" they're referencing the Fourth Amendment. So you have to have a warrant that specifically states what they're looking for and where the thing is or who has it, right? So the police cannot just barge into your home and look for evidence of criminal activity. There are a number of exceptions to this. This is something that has been litigated extensively and is extremely important for criminal procedure. And we're going to look at it, analyze it when we have our class about American criminal procedure. There are many exceptions, but in general, you call it the exclusionary rule. If any evidence for a criminal case was obtained illegally in violation of the Fourth Amendment, then that evidence has to be excluded, even if that means that the defendant will be found not guilty. So it cannot be argued before a jury. Illegal evidence cannot be admitted in court. There are exceptions to it. There's hot pursuit, there's exigent circumstances, but we're going to analyze it in our criminal procedure class. There's also plain view. So basically, if you have something on you, if you have drugs on your visible on your body, then that's plain view. You don't need a warrant for that. But like I said, we'll analyze that in a criminal procedure class. So here's some relevant case law. You do have to read Matt versus Ohio for our class. So that's where the exclusionary rule comes from. It's an important decision. But you also have Terry versus Ohio, Maryland versus King, and a bunch of other decisions. Like I said, this is not even close to being all of it. It's been litigated very extensively. So these are just some of the most important cases. The Fifth Amendment, also extremely important, protects you from self-incrimination. So no person shall be compelled to testify against themselves. So you have the right to remain silent. You know that from the Miranda versus Arizona case. Also something you have to read for the course. Also the protection against double jeopardy. That means being brought to trial twice for the same offense. That cannot happen. There are exceptions to that. It's not as absolute as in our country. There's no double jeopardy. If you're brought to trial in a state court and a federal court, it doesn't count as double jeopardy. But if you're found not guilty by a jury, then that decision cannot be reviewed. That's it. That's definitive. When you plead the fifth, when you take the stand and plead the fifth, for instance, in a Senate inquiry, that means you're not saying anything because you're afraid that you might incriminate yourself, and you have the right to do that. In a criminal trial, you can choose not to take the stand, but if you take the stand, you cannot plead the fifth. And obviously, this applies to basically any communication with the government. This is why the Miranda warnings exist. Because if you're detained by police officers, they cannot use your statements against you unless they've warned you about that. So that's what the warnings are for. That's why you always see police officers doing that after people are arrested. Because if people say anything immediately after the arrest, which might be used as evidence against them, they need to have been Mirandized, which means they have to have been read their Miranda rights in order for that to be admissible evidence in court. Also, grand juries and due process. A grand jury basically is a jury trial that happens before the trial itself, which only has the prosecutor. There's no defense attorney. Basically, the defendant and the prosecutor will go to the grand jury and they'll say, and to the judge, and they'll say, does the jury think there's enough evidence to indict this person, and then take them to trial in this matter, and the jury can vote yes or no. And if the person is indicted, they're not convicted yet, then the case goes to trial normally, and then the person has the right to have a defense attorney present. This is the one thing that has not been selectively incorporated in the states. So state trials don't have to have grand juries. Many do, but they're not required to have one. Federal trials at the federal level, so in a federal court, do have to have grand juries. So that's a constitutional requirement. So Miranda versus Arizona, obviously, it's a big case. I think it's one of the bigger cases that I set out for the students to read. But extremely important, obviously, and you have to read it. So, also, like I said, a million cases of Fifth Amendment cases. So, if you read this, I think you have a good understanding for someone who's not from the United States. But for an American lawyer, this wouldn't even come close to being enough of Fifth Amendment case law. So the Sixth Amendment basically protects your right to have a jury trial. You are entitled to a jury trial for all cases above 6 months. Cases where you might be convicted of a sentence of imprisonment longer than 6 months. So it can be a misdemeanor offense or a felony. But if you're under threat of being imprisoned for more than 6 months, then you're entitled to a jury trial. You can choose to waive your right to a jury trial by a plea deal. But if you don't, then you have to have the jury trial. And this is a big problem in America because obviously it's a big country, it has a big prison population. Because they cannot provide jury trials for everyone, there's a big incentive to take a plea deal, which is why the vast majority of cases in America don't go to trial. People just take the plea deal because it's very tempting. And in fact, many people don't consider that to be a very fair thing because the prosecution is basically threatening you, saying if you do take this to trial, I'm going to give you a much bigger sentence. And obviously that you're foregoing your right to go to trial. Maybe you're innocent and you still have to plead guilty. Or you can also plead non-contest. That's also a possibility when you take a plea deal. That's how it works. That's how they managed to maintain the Sixth Amendment without giving every single defendant a jury trial, because that would cost a lot of money and would take a lot of time. Jury trials usually, they take a lot of time, and sometimes, there's something called the sequester jury. So if the defendant is a famous person, you saw this happen in the O.J. Simpson case, the jury might be, isolated from the rest of the world to make sure that the other people are not going to influence their decision. So obviously, when that happens, that makes the costs go up a lot, and it would be a huge burden on the state coffers if they had to provide jury trials for every single offense, which is why the majority of cases just end up in a plea bargain. So the Supreme Court has ruled on many aspects of the jury trials, one of them being the number of jurors. So for instance, it has to be at least 6, and usually it's 12, but it has to be at least 6. Less than that, and it's a violation of the Sixth Amendment. The jury has to be a cross-section of the community, right? So it's not going to just be lawyers or experts. It has to be random people, that represent the community. And it's going to have to be from the same district, and it's actually in the text here. The district shall have been previously ascertained by law. So impartial jury of the state and district wherein the crime shall have been committed. So you have to look at the cross-section of the community in that state, in that district. The trial must be public and speedy. This is a general idea of law. They're also not entitled to a closed trial. You saw this, trials have to be public. And there's the possibility of having a mistrial. So let's say you have a defense attorney, which was appointed by the court. Also, you're entitled to a defense attorney by the Sixth Amendment. And he starts to speak ill of you. He starts to act against your interest. That would be a case of a mistrial, because you're entitled to legal representation, and that representation cannot act against you. So that would be a mistrial, and the case would have to go to court again, and you have to get a brand new jury, and you have to do everything all over again. So you can see how the cost can really balloon for a jury trial, which is why only if you're facing a really long sentence, a life sentence, a death sentence, is it generally worth it to actually go to trial, even though you're always entitled to a trial, except less than 6 months in prison. So Seventh Amendment, this one is very interesting for us. This is a civil jury trials in civil cases in suits at common law. So in our first lesson, I spoke about the difference between common law and equity, and this is a place where it comes up. Because if it's a suit at equity, you can say, well, then the person that's litigating is not entitled to a jury trial. But if it's a common law suit before a federal court, then there has to be a jury trial. This is something that has not been selectively incorporated by the 14th Amendment, which means it only applies to the federal government. The state courts do not have to have jury trials for suits at common law, but they're allowed to have one if they want to. When it comes to the jurors themselves, the rules for the jury selection are the same in civil and criminal cases. So it has to be at least 6, cross-section of the community, but the vote does not need to be unanimous. That's a difference from the criminal jury. And you have your 2 attorneys. There's no prosecutor because it's a private matter. So you have the opposing counsel and you have your counsel, and you're both trying to get the jury to rule favorably to your case, right? Voir dire, I'm going to explain this in our civil procedure and criminal procedure classes, but basically, there's a number of steps to selecting the jurors. Also, the amendment itself talks about $20, but that has never come up in the court, because the costs of going to trial in the United States are very high, and there's no possibility of getting public free counsel in a civil suit. So if someone sues you, even if it's completely unfair, you have to pay for your own attorney, and that's something that's a lot of people consider unfair. Because someone who has a lot of money can just sue you. It can be a bogus lawsuit, but you don't have money to defend yourself, and that's a huge issue. So here's some relevant case law. Like I said, this isn't the only time we hear about this. We're going to have our civil procedure law class, and I'm going to explain these things in more detail. But basically, this is what I quoted in the first class. You have Grand Financiera versus Norberg, and also Slocum versus New York. Like I said, among many, many others. Right, so the 8th Amendment, also very important for criminal law. So excessive bail shall not be required, nor excessive fines, nor cruel and unusual punishments inflicted. So when it comes to the death penalty itself, that has been, right now, as of today, the understanding is that it's constitutional to have the death penalty, with a lot of exceptions. So it cannot be cruel, it cannot be done against minors, it has to be a serious offense, but overall it's considered constitutional. But things like burning people alive or torture, those are cruel and unusual punishments. So the execution itself has to be humane. So you have lethal injection, firing squad, those are considered humane forms of execution. Excessive bail has not been found to be applicable to all states, which it's a pity, but excessive bail is a problem because bail is very common in the United States. Basically what it means is you go to court, you have a bail hearing before the judge, and the judge sets an amount of bail for you. You can also choose not to set bail and to set some other condition, but basically when you pay bail, that's basically a guarantee to the judge that you will return to the court to actually go to hear the full case, to hear the full trial, and to be present at the trial, and you're not going to run away. So you pay, $100,000 in bail. At the end of the trial, you get that money back. If you're acquitted, you get that money back. If you're convicted, sometimes that money goes toward paying the victims, paying reparations. But basically, it's an incentive. If you want your money back, you have to show up here to the actual trial. So that's why you pay bail. It's something that we don't do very often in Brazil, but in the United States, it's very common for judges to set bail. All right, so a lot of things here. But also, an interesting aspect is the idea of proportionality between the punishment for a crime and the crime itself. So if it's not a very serious offense, you cannot have an extremely long prison sentence, right? So this is something that It's an interesting application of the 8th Amendment. So the 9th and 10th Amendment, these are basically those catch-all amendments. It's just basically saying the list of rights in the Bill of Rights isn't exhaustive. There's other rights, which maybe Congress can institute, or they can be understood as existing within the lines of the Bill of Rights. So it's not an exhaustive list. You can say you're not entitled to that because it's not in the Bill of Rights, because the 9th Amendment protects you against that. And this is something that came up a lot in the 60s, and this is one of the things that helped build on the idea of a constitutional right to privacy, in the case Griswold versus Connecticut. And it's something that's being disputed by the Supreme Court today. So you had a recent case, Dobbs versus Women's Health Organization, I believe, which is a Supreme Court case, very recent, from a few years ago, where they overruled the idea of a constitutional right to abortion, which had been established in Roe versus Wade in the 70s. So this is something that's being disputed today, and it's a lot of litigation based not on the amendment itself, but on the idea that the amendment brings, right? So you use this amendment in conjunction with other amendments. And the 10th Amendment here, let me skip ahead a little bit, basically saying that which has not been done by Congress and it's not prohibited by the Constitution shall be done by the states. So that gives the states a lot of leeway in creating their own regulations. It's a case of the United States Public Works versus Mitchell, basically talking, about right of political partisanship by employees of the government. So this was a case where a few employees were striking. It's not very relevant to us, but it's just that there isn't a lot of 9th Amendment cases before the 1960s, which is when the court really began to apply 9th Amendment and the 10th Amendment more broadly, So you have other decisions from that time, such as Brown versus Board of Education, really try to bring, a more expansive idea to the Constitution, which is not so limited to the original meaning. And that has changed dramatically in the past decade. So the Supreme Court has gone back, or perhaps even gone further than before, in affirming that only the original meaning of the Constitution and not the amendments is valid, right? So there's no extensive interpretation that is admitted today by the conservative majority in the Supreme Court. Also talking about the limitations of Congress. This is an interesting case here. The Fair Labor Standards Act is one of the main pieces of legislation at the federal level dealing with labor law, and we're going to analyze this during our labor law class. But basically, the government has the power to regulate interstate commerce, and they use that to justify labor regulations at a federal level. Because some people were claiming this is a violation of the 10th Amendment, because it's the state, it's the federal government stepping into something that should only be regulated by the states. And you see that happening a lot with education. There's a lot of people in the United States who believe that the Department of Education at the federal level should not exist because education should be solely governed by the states and not by the federal government. All right, so those are the amendments for the Bill of Rights. The first 10 amendments, there have been amendments ever since the Bill of Rights. Some of them taking place right after the Bill of Rights was approved, and others, coming much, much later. So we'll start with the 11th Amendment, something that really doesn't come up a lot in court, but it's basically a limitation of judicial power. It prevents citizens from suing their own states at a federal court, which is seen as a way to protect, the states from, being encroached upon by the federal government through the federal judiciary. The citizens can sue their states at their own state court. That can be brought before the Supreme Court on appellate jurisdiction, but they cannot sue their states at a federal court. And this was basically a response to a suit brought by a citizen. The name of the case, it's a very old case. It's one of the very first Supreme Court cases. Sisholm versus Georgia, 1793, right? So this was basically a response because the Congress and the states in particular did not like the decision that the Supreme Court made in that case. The states can sue each other and the federal government can sue states, but citizens cannot sue the states in a federal court. That's basically what the most important thing that the 11th Amendment does. All right, so the 12th Amendment, also not something that shows up in court a lot. Basically, before this amendment, the vice president was the person who got the second most electoral votes. The president is selected by the electoral college. And the way that works today, because it has changed a lot, and it's a whole thing, it's American history to talk about how it used to work back then. But today, the way it works is, whoever gets the most votes in the state gets all the electoral votes for that state, except, states that have different districts, such as Nebraska and Maine. And the electoral votes basically is just, how many votes you have in Congress, how many seats you have in Congress, and the 2 seats in the Senate, right? So if you have 1 seat in Congress and 2 seats in the Senate, you get 3 electoral votes. Obviously, that creates a distortion that favors the smaller states because they get more electoral votes per citizen. And until the 12th Amendment, the person with the second most electoral votes became the vice president. And, this was a very bad idea because it basically created a president and a vice president who were at odds with each other. There was constantly, they would constantly be in conflict. And today, the vice president is elected in the same ticket. So people vote for a president and they vote for the vice president. So it's a separate vote. And when the Electoral College meets in Washington, they have separate votes for president and vice president. And basically the vice president today is a part of the president's cabinet and he's an important advisor. And he's also the president of the Senate. So he has the ability to cast the tiebreaker vote, or she has today, because the vice president today is Kamala Harris, a woman, for the first woman to become vice president. And she has the ability to cast a tiebreaker vote, right? If Congress is tied, so it's a 50-50 vote because it's 100 members, the vice president can come in and cast a tiebreaker vote and sort of break the tie. Relevant case law, like I said, doesn't come up a lot. 13th Amendment. This is very important. This is the amendment that abolished slavery. So neither slavery nor involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States. So this is, people criticize this part about the criminal punishment. So if you go to prison, you can, according to the language of the amendment, they can use you as a slave, which is something they criticize. And some people, people think that one of the reasons America has such a large prison population is all the labor that can be exploited from the prison population for free. But it was obviously a very important amendment because it abolished slavery in the United States, which is very good because there were a lot of parts of the original provisions of the Constitution which were protective of slavery. This came in 1863. It finally abolished it. Basically, it's something that doesn't come up super often, but it does come up a few times, but not as often, as other amendments such as the 14th or the 5th or the 1st, but it has come up a number of times. It also applies not only to the traditional idea of slaves, but also these contracts which are basically slavery, such as peonage, or when you have a person that's like just working in your house and they live with you. This was the case in the United States versus Kosminski, which is a very recent case, 1987. Basically, a man who had some intellectual disabilities, and he was living with his family, and he was not getting paid. So, to them, the Supreme Court held that this was a 13th Amendment violation, and also other things. Bailey versus Alabama, we're talking about peonage, which is an old form of a contract which doesn't really exist anymore, but it was basically like a feudal contract of servitude, and it was a violation of the idea of involuntary servitude. Here are some important cases. You have this case here. I think it's extremely interesting. Jones versus Alfred Meyer, because it's a case where the line of arguing adopted by the Supreme Court was not really an originalist meaning. It was more like the intention of the Supreme Court, of the Constitution amendment. So I think it's interesting because it's really contrasts with other decisions, especially more recent ones. The 14th Amendment, it's a huge amendment. It was meant basically to remedy all the injustices that were still left over even with the abolition of slavery, in particular towards African American citizens. So basically, you have due process in a court of law. You have equal treatment under the law. So a lot of things that we associate with constitutional protections come from the 14th Amendment. Almost every important case had something to do with the 14th Amendment. So Brown versus Board of Education, or Obergefell versus Hodges. So it's probably, when it comes to protections and rights, one of the most important ones. And also, it affected all the other amendments as well, because it brought the idea of a selective incorporation. So it said basically the amendments did not only apply to the federal government, but also to the state governments. And this was the doctrine that was constructed with decisions over time. It has also a section that applies that everyone who's born in the United States is a United States citizen. All individuals born there, so there's jus solis, and this is good because this is how a lot of immigrants became citizens, right? So their children became citizens, and usually as a result of that, they eventually become citizens themselves. And it was good because it basically provided citizenship to all the people who were slaves before the 13th Amendment. But also, it had a lot to do with the Civil War. So Section 3 talks about rebellion. So this was to exclude all the people involved in the Civil War from the political sphere. So if you were like a Confederate general or Confederate governor or the Confederate president, you cannot become then a member of Congress in the post-war United States. So really, this is a very big amendment with a lot of text, and not all of it has been applied. For instance, some people think this should be applied recently to the Capitol riots in the U.S. Also, Section 4 here. So basically, reforming the Constitution to remove any mention or idea that could support slavery or racial discrimination, which is why this was the basis for a lot of decisions following this case, right? Because the entire system was basically revamped. And in particular, you had this with the 15th Amendment, which was specifically against segregation and discrimination on the basis of race, especially when it came to voting rights. So, birthright citizenship, like I mentioned, this is good for all the African Americans, but it has been used for every single person born in America ever since, has been a U.S. citizen, unless, they're not under the jurisdiction. So that usually only applies to, diplomats or military members of other countries whose parents were serving a different country when they were born in the United States. But even if you go to the United States illegally and you were born there, the Constitution does protect, the Supreme Court has upheld this in the 1890s, does give you citizenship at birth. So you're a naturally born citizen, and you can run for president, you can do anything you want as an American. Right, so no state shall deprive any person of life, liberty, or property without due process of law. So this is a big restriction, and it has been applied quite liberally, which is something a lot of conservative justices criticize. They say, well, this isn't a prohibition against perhaps certain bills, but it's only saying that if a certain thing is going to be criminalized or punished, then there has to be due process. This came up in Lawrence versus Texas, which is one of the cases that the students have to read. In this case, Scalia basically said, well, there's no prohibition against criminalizing sodomy as long as there's due process. He was in the minority in that case. He had a dissenting opinion. It's an interesting opinion. I think you should read it. I think you should read all the dissenting opinions on the mandatory cases, especially because they provide a little bit more context on how American law works. Also, equal protection of the law, basically. So, you think Brown versus Board of Education, it comes from this particular segment of the 14th Amendment. So apportionment in Congress, basically this was to get rid of the idea of a 3/5 compromise, because the Constitution said before that it was meant to count 3/5 of all other persons in the states. That basically just meant people under slavery. They only counted as 3/5 of a person when determining how many representatives each state was going to get in the House of Representatives. So this portion of the amendment completely avoided that part of the original provisions of the Constitution. So the 3/5 idea of the Constitution has no value anymore. So basically the most litigated amendment, and perhaps one of the most important amendments. Certainly, there's the 13th Amendment perhaps is historically more significant, but this is a very, very important amendment in American history. In approaching this problem, we're talking here about Brown versus Board of Education. Basically, there was a decision in the 1990s called Plessy versus Ferguson, and it said that racial segregation was legal as long as people were provided with equal infrastructure. So it was the idea of separate but equal. The trains could be segregated, but they would have to be equal. Obviously, that was never really, people that never really obeyed that. Some of the trains were always going to be worse and more neglected. But basically, they struck that down and said, no, there can be no segregation under the law in the United States. Which is why it's also an extremely significant decision. And obviously, one of the most famous decisions is a decision that you have to read. And it's also a very short decision. And you're going to see when you read it. So it's good news for the students. So equal protection, Logging versus Virginia. This is a decision that made bans against interracial marriage. It wasn't just bans. It was a crime to marry outside of your race. And the criteria that they utilized was obviously ridiculous, but it went basically, if you had any amount of even something like a quarter of a different race, so you could be basically African, people of African ancestry could not marry people of European ancestry, even if it was only like a quarter, they had only one grandparent was an African American, they still could not marry outside of the race, and it was an actual crime. So people actually went to jail as a result of those statutory provisions, and they were all struck down by idea of equal protection under the law. in the case Loving versus Virginia. A lot of these cases from the 60s, which use the 14th Amendment to strike down segregation, are very similar, which is why you don't have to read all of them. But it's interesting, they're not very long. They're very easy to understand, so I've only put a handful in the mandatory reading list. Lawrence versus Texas, 2003, basically struck down all sodomy law, all anti-sodomy laws in the United States. Basically, until 2003, in certain states, it was a crime to engage in any sort of homosexual conduct, which is crazy for us to think, but yeah, it was very recent. And in states like Idaho, the punishment could be quite severe. It was not enforced so much, but the law was still in the books. In fact, it's still in the books today. So if you look at the laws for a state like Idaho today, the laws against sodomy is what they call it, are still there. And if this decision was to be struck down by the new conservative court, those laws would kick back into effect. So it's a scary thing to think about. And it was only really changed in 2003, which is extremely recently. Griswold versus Connecticut, the idea of a constitutional right to privacy. The original context was birth control. Birth control pills being made illegal by state law. They basically said, well, you can't do that because people have a right to make a decision themselves. They have a right to privacy in their own homes. It was naturally, the original idea was to protect, heterosexual marriages and traditional families. It's been expanded significantly since then, and it's being changed right now. So maybe they'll overrule this entire decision soon. As of right now, they've overruled Roe versus Wade, which was based in part on the idea of a constitutional right to privacy. So you have to keep up to date with the constant changes, in the American case law. So obviously, this is just a few decisions. The amount of decisions is enormous. It wouldn't fit. I would have to, I'm sure nobody really knows how many decisions have been done on the basis of the 14th Amendment, and obviously that includes me. So this is just basically really the most important ones, the basics. But if you really want an in-depth review, you're going to have to read a lot more case law than this. Well, the 15th Amendment, we're talking about voting rights. So voting rights cannot be restricted on the basis of color, basically, race. And what's interesting to think about is that right after the Civil War in the 1870s, there were a lot of African Americans being elected into Congress. And the reason that happened was the states in the South were very limited in their power following the war. You call that period Reconstruction. So there was an intervention by the federal government in those states. But after they gained their autonomy and their sovereignty within the Federation, they started passing ways to discriminate and limit voting rights. Obviously, they have to construct these elaborate ways of limiting voting rights without violating the 15th Amendment. One of the ways they did that was with a poll tax. So you have to pay a tax to be able to vote, or you have to be literate to be able to vote, or you have to present an ID, or something like that, which was always meant to discriminate, against minorities. So much so that those prohibitions were only enforced selectively. They made exceptions for white citizens, which is why they had to amend the constitutions a few more times. There's an amendment after this specifically against poll taxes. So poll taxes today in the United States are unconstitutional. Voting has to be free. Obviously, you can't be forced to pay a tax for voting. Well, like I said, the U.S. Congress following the Civil War, and you had kind of a pause on African American representation in the Congress following Reconstruction. So it's interesting to see how things regressed basically. And there's this whole idea of a lost cause and the Confederacy, and these Confederate monuments being built in the early 1900s or in the 1950s. Basically, whenever there was some gains for the African American community in the United States, there was pushback, which led to this mythology surrounding the Civil War to increase in popularity. It's still something that happens today. So there's still Confederate monuments around the United States today. Here we have United States versus Reese. It's talking about a poll tax. This didn't outlaw poll taxes in general. It just said this particular bill was enforced so selectively that it was unconstitutional, basically. And what you had here was that after this decision, they went and they changed the law. They made a grandfather clause, right? And they said anyone who could vote before can still vote, and the people who couldn't vote have 2 weeks to vote or they'll never be able to vote. And that was also ruled as unconstitutional. So basically, they were always trying to come up with new ways to limit voting rights, and still are, honestly. Lane versus Wilson. Yes, this is what I'm talking about. So they made this grandfather clause in 1914. They were forced to change it, but they changed it so little that the Supreme Court had to step in again. And then Smith versus Allwright talks about participation in political primaries. So primaries in the United States, just because every election in the United States is first past the post, basically that led to, you know, only there are only existing two major political parties, even though that's not like limited by law or regulated by law at all. It's just, you know, a result of, you know, the system that they have. And because there's only two parties, they have primaries. So in these primaries, you know, a lot of people are allowed to run for the position, which will then go on to, you know, dispute compete in the general election against the other parties. And basically the government said, well, because these primaries are so essential to the election, even though they take place within the context of a private institution, which is a political party, because political parties are really loose things in the United States. They're not really nearly as tightly regulated as here. If you want to leave your party or betray your party, you're allowed to. Because these things are so essential to the electoral process, they're also barred from discrimination. So you cannot say people of this or that race are not allowed to run in the political primary for my state. So these primaries are not exempt from constitutional protections. Then you have Gamillion versus Lightfoot. This is about gerrymandering, basically. Gerrymandering being, you know, drawing political maps in a way that excludes certain citizens. They still do this today. The Supreme Court just said you can't do it on the basis of race, but you can do it, you know, like income. Those things are still allowed. There have been a few cases in the last few months, you know, reinforcing these prohibitions against, you know, discriminatory gerrymandering, but it's still something that gets done. But it's basically just saying that the gerrymandering cannot be done on the basis of race. So here's some relevant case law. Like I think I went over most of this. But basically, if you want to read more about it, obviously you have to go beyond this. And post-Civil War, right? Because all these amendments, they were done, obviously not during the Civil War, except the 13th Amendment was during the Civil War. They were mostly done right after, in the immediate aftermath. The amendments we're going to talk about now were done, you know, several decades after the Civil War. Starting with the 16th Amendment, which basically gave Congress the power to institute a federal income tax without apportioning it the money, right? So they didn't have to say. They didn't have to count the amount of citizens in each state and distribute the money from the income revenue, the income tax, according to the population of each state. They were free to really use that money in any way they saw fit. And this allowed government basically to drastically increase their revenue. We're going to talk about that during the tax law class. Yeah, so basically 1913, and this was a response to a decision a few years before that. I think I have it here. Well, I can't find the name now, but we'll talk about it during here you go, Pollock versus Farmers Loan Trust. Basically, this is the decision that inspired the 16th Amendment, because they basically said if you're going to have a tax, you have to, it's a direct tax from the citizens, you have to distribute it according to the census data. And basically they had to amend the Constitution to say, no, we're actually allowed to do this. Yeah, we'll talk about this in greater detail during the tax law class. The 17th Amendment, this is where they changed the law so that the senators from the states would not be selected by state legislatures, but by the people of each state. So there will be elections for the Senate as well. And this only happened in the last century. So for a long time in American history, people did not vote for the Senate. And this is interesting because most upper chambers in English-speaking countries are comprised of unelected members. So you think of places like Canada or the UK, you have an upper chamber that is made up of people who are not elected. So it's sort of an Anglo common law tradition to have an unelected upper chamber, but this was changed with the 17th Amendment. Basically, you know, expanding democracy, having more elections, giving people more power to vote, which in general is always a good thing. And when we think about this amendment, really, it's something that we forget, but people don't really remember that there was a time when the senators were not elected by the people. But it's actually sort of recent if you think about the whole scope of American history, sort of going over more than a century without elections for the Senate. So the 18th Amendment, this one is interesting. This is probably the funniest, it's a bit tragic what happened as a result of it, but it's perhaps the most peculiar amendment in the Constitution. Basically, this instituted prohibition. It's crazy for us to think that, you know, the American Constitution being so hard to amend, that they would prohibit alcohol using a constitutional amendment and not just a basic bill, basically. But that's what they did. There was a constitutional amendment and it said all intoxicating liquors will be prohibited. And this amendment was in effect for around 15 years, more or less. And, when you think about the increase of violence, the period of prohibition in the 1920s, we think about famous criminals such as Al Capone. Basically, this led to a lot of violence because the demand for alcohol did not go away after this amendment was approved. And actually, I skipped the 19th and 20th Amendment because I think it's important to talk about the 21st Amendment because it repealed the 18th Amendment, basically. And this is interesting because this really hadn't happened before, except for the Civil War amendments regarding slavery. Basically, just came in and were like, yeah, that amendment doesn't work anymore because it was leading to so many problems that they just repealed it. But they said, if states want to prohibit liquor within their own jurisdictions, they're allowed to. This is why some counties in the U.S. are still dry counties. So in some places in the U.S., alcohol is actually prohibited. So they have the power to prohibit alcohol based on the 21st Amendment. So we started this prohibition era. We romanticized, but really it was there was a lot of violence and a lot of corruption happening because of the 18th Amendment. That's why it was ultimately repealed, especially during the Great Depression, because it was already a huge economic crisis, and the alcohol prohibition only made things worse because everyone basically turned to illegal bootleg alcohol. And when you think about these popular culture things about moonshine and bootleg alcohol, you go back to prohibition and the 18th Amendment. So which was repealed by a new amendment in 1933. Right. So the 19th Amendment doesn't have to. I skipped. Going back to it now. It's extending the right to vote. So suffrage. Suffrage means the right to vote to women, basically. And this happened obviously very well. Clearly, it should have been the case from the beginning, but it only happened in the beginning of the 20th century. And there actually is a connection between women's right to vote and the prohibition of alcohol. Because the people leading the charge against alcohol were women. There was something called the temperance movement. And at the same time, there's also this movement by women called the suffragettes trying to extend the right to vote to women. So it was a time of heightened political participation by women in American politics. And you can basically say that they managed to approve two amendments, one of them being this very important 19th Amendment and the other one being the 18th, which is not in effect anymore. So the 19th Amendment basically gave women the right to vote. And as I was saying, this amendment, you can see some sort of historical connection with the 18th Amendment in that the movement to approve this amendment, just like the 18th Amendment, was spearheaded by women. So in the case of the 19th Amendment, you had the movement called the suffragettes. So it was women protesting for the right to vote. But also you had a lot of women, and there was something called the temperance movement, which is basically a movement mostly made up of women who were opposed to alcohol, right? So they led this huge societal revolt against alcohol and managed to get an amendment passed, which is extremely impressive in American politics. So as I was saying, there is the 19th Amendment here, is the amendment that gave women the right to vote basically across the entire country. There were some local efforts to extend the right to vote to women. The first state to do so was Wyoming, but this made it basically for all the states had to extend the right to vote to women. Obviously, it had different requirements than men, but it was extended to women. And basically, there's a historical connection between the 18th and 19th Amendment. And the 19th Amendment was led by the suffragettes, which were a group of women protesting for the right to vote. But the 18th Amendment was also, approved because of, protests and movements led by women, by the temperance movement, who were against alcohol and the societal impacts of alcohol. You have things like domestic violence, which is still a problem today, obviously. Both of these amendments were basically spearheaded by women. And this was extremely impressive because, as I discussed before with you guys, getting an amendment approved is very difficult. So the fact that they managed to get two amendments approved, in a short period of time, it was very impressive. And it's a testament to the increased participation in politics by women, which really never changed after that. So not a lot of litigation has been brought before the courts for the 19th Amendment. There's the Lesser versus Gurnett case, basically just saying, the amendment was approved correctly. But basically, the amendment's pretty clear. Just the rights of women would not be obliged on the basis of sex. There was so much societal change in that time period that there's never really been, any litigation on this basis, especially because, the leading issue of voting rights discrimination in America has been primarily the issue of race. I can't remember any, ever since the 19th Amendment was approved, of anything significant effort to derail voting by women. But I can obviously remember the efforts to derail voting by minorities, and it's mostly because the female vote has usually been split evenly among political parties, so it's not really interesting to divide that. The 20th Amendment, basically just the inauguration used to be in March, and it was moved to January 20th. So the new president would be elected in November. The election in America is always in November, and they would have to wait until March to be inaugurated. And that was a long wait. It's a period, you call that the lame duck period, where the sitting president, basically he's still in office, he still has all the powers of the presidency, but there's already a replacement that's been chosen and selected and it's underway. So no one's going to negotiate or do anything with that president because they're just waiting for the replacement to step in. So yeah, basically they reduced the lame duck period because it's a period where the president is weakened politically, and that's not good, especially in turbulent times such as the ones we live in. And it's still a long lame duck period today. From early November until January 20th, there's a lot of room for things to go wrong during that period, the time. Yeah, basically lame duck period, important term. Basically, president's in office, but there's another president on the way, or another governor. Basically, that person has no political power, even though they still have legal power. Yeah, Bush v. Gore is here, I think, in part because the decision had to be made sort of hastily, because they hadn't clearly decided the winner. They hadn't counted all the votes until December. The inauguration was fast approaching, and you don't just need the inauguration, you also need to appoint government officers. So you see that this is something that is at odds with the way American elections are conducted, where you have all this wait to discover who the winner was, and the short lame duck period where you need to start working on the transition as fast as possible. The 22nd Amendment, basically term limits for the presidency. There were no term limits for the presidency before this amendment. Prior to this amendment, which is in the halfway through the 20th century, and basically this had never really been a problem, because George Washington, being the first president, he basically created this precedent. Obviously, it was an abiding precedent. It was just a tradition that you would serve 2 terms and then you would leave. And throughout the 19th century in America, most presidents were one-term presidents. It was a time where the office of president wasn't very powerful. It became very, very powerful in the early 20th century with IRS and the world wars. Basically, the federal government became much larger, and the president, as a result, became much more powerful. During the 19th century, the United States president was not as powerful as he is today in terms of the political system. Basically, even though it was possible, no one had ever successfully won a 3rd term. A few people had tried. Theodore Roosevelt had tried to run for a 3rd term. The only person who managed to be elected for more than 2 terms was Franklin Roosevelt, in the context of the Great Depression and the Second World War. He was actually elected 4 times. He served 3 full terms, and then he died a few weeks into his 4th term, which is how he ruled for 12 years as U.S. president. But basically saying, that's not going to happen again. So the 23rd Amendment, basically, I was talking earlier that the District of Columbia doesn't send representatives to Congress, and that's true. But they do send electors to the presidential election, so they have the right to vote in the presidential election. And that is thanks to the 23rd Amendment. So that was something that they did, but they still don't have, voting members in Congress. So they only send a representative to the House of Representatives who is not allowed to vote. They don't have senators or congressmen. So there's still a problem of political representation in Washington, D.C. And, it's the place where 1 million people live. The way it works today is that Washington, D.C. is governed by Congress. The policies that exist in Washington, D.C., even though there's some form of local government, ultimately are decided by Congress. When Washington, D.C. tried to legalize marijuana to their own local government, basically Congress stepped in and didn't let them do that because they still have the final say. And this is based in the fact that the Constitution does say that there needs to be some sort of district, neutral district. Some people have argued that if the District of Columbia was to become a state, they could just make the land surrounding the Capitol building, this district that the Constitution mentions, but it still hasn't really going forward. There's some bills in Congress trying to make DC a state right now. It doesn't look like it's going to happen imminently. Maybe that will change the future. Yeah, obviously, it's, again, very, very straightforward. No case has made it to the Supreme Court. 24th Amendment, like I said earlier, poll tax used extensively to suppress the African American vote was finally made unconstitutional by the 24th Amendment. It was, in the context of the Voting Rights Act and the Civil Rights Movement, there was a lot of disenfranchisement happening, and one of the principal ways they could do that without bypassing the Constitution was through the poll tax, because people had to pay, and if you didn't pay, you couldn't vote. And even if you did pay, they could just pretend that you hadn't paid or you hadn't paid correctly and basically not allow you to vote. Right. So 25th Amendment, interesting amendment. You see this, this was brought up a lot. This has been brought up a lot in the past 5 years. Basically, it creates a procedure through which the president can be removed without an impeachment. So, the vice president, he convenes with the presidential cabinet, that's the president's advisors, and he's like, okay, I don't think the president is capable of discharging his duties, so I'm going to remove him from office, right? This has to be approved by Congress, but it's a way to do it without an impeachment trial. So it's a much faster, but you still need a 2/3 vote by Congress. So the political cost is the same, but it's just faster. And you don't need a crime. It could be like a medical reason. This happened during, for instance, it doesn't have to be permanent. You just say, I'm going to discharge, the vice president can just say, I'm going to discharge the duties of the presidency for a few days, a few weeks. For instance, if the president is incapacitated. So there's this concern with the continuity of government. This was brought up a lot during 9/11. This amendment is from before 9/11. What happens if the president is killed and the vice president is killed? Who's in charge then? They created a whole chain of command and the line of succession, and this sort of helps with that, because it gives clear directions. So what to do if the president is incapacitated? This is you have to think of the Cold War, the fact that the president always has the nuclear codes. It is a pretty urgent matter. So that's why the president is sort of always on duty. Even when he's asleep, he can be awakened at any time. And that's also why the vice president and the president are usually kept in separate places. So the vice president can step in. This happened during 9/11 because the President Bush, he was in Florida. He was on the Air Force One, and it was sort of hard to reach him. So a lot of the decisions on that day were made by the vice president. Yeah, basically, another thing this did is that it made it official, even though this had already been the norm. It made it constitutionally official that in the case the presidency was vacated, it was to be taken over by the vice president. The first time a president died in office was William Henry Harrison, who died in 1 month into his presidential term. Basically, the vice president took over, but people were very confused by that because there wasn't really any procedure in the Constitution. The Constitution wasn't very clear what was to happen if the president died or was incapacitated. But then it was basically established that it would be the vice president who took over. Basically, this made it official. It's in the Constitution now. So also it provides procedure to fill in the post of vice president if the vice president is incapacitated or dies. This has happened before historically. So in the 1970s, Richard Nixon's vice president, Spiro Agnew, basically, this is just an explanation of what it does, basically stepped down because of the Watergate corruption scandal. Basically, Congress voted for a new vice president and appointed a new vice president. Nixon picked a vice president and he was approved by Congress. And that person was Gerald Ford. What's interesting is that Gerald Ford then went on to resign the presidency. Richard Nixon resigned from the presidency, and Gerald Ford became the president, even though he never received any electoral votes for vice president or for president. So that's how you do that, and this is something that shows up in those political dramas. You saw this in House of Cards, because it's a way almost to do like some sort of power grab. Obviously, that's not what happened in the 70s, but you could basically become the president without being elected, basically, through the 25th Amendment by being appointed vice president in the case of a vice presidential vacancy. And then the 26th Amendment in terms of age. So if you're 18 years old, you can vote in federal elections, and that cannot be obliged. So before that, it was 21. It's sort of a confusing gray area in American law. Like when you're between 18 and 21, you can't drink. There's a lot of things you can't do. But basically 18, you're legally an adult, even though there's a lot of limitations still. And as such, you can vote. You cannot be elected for all offices. There are requirements, for instance. The president has to be at least 35. senators have to be at least 30, but when you're 18, you can vote for any office in a federal election. And then 27th Amendment, very interesting amendment. This is the last amendment to the Constitution. Basically just saying that the pay given to members of Congress will not be increased until the next legislature. So if you approve a pay raise, that's not going to take effect until the next election. And that's good because if the public is outraged by this pay increase, basically they can vote out the people who approve this increase in pay. Basically the new elected officials will just strike that down. That's the idea. And what's really interesting historically about this amendment is that this amendment actually was introduced in the 1700s. It was introduced with the first 10 amendments. It was approved by Congress, but the states never ratified it. It never achieved enough states, ratification by enough states to become a constitutional amendment. But because they did not set a time limit, they didn't say, oh, it has to be ratified by this date or some other date. Basically, all that had to happen for it to become part of the Constitution was for enough states to ratify it. So what happened is a student in Texas noticed this. He wrote a paper saying that, it would still be possible for this amendment to be approved. And his professor gave him a low grade because he was like, that's not a convincing argument. But ultimately, he was victorious because he got the amendment ratified by a few extra states, and then it actually became part of the Constitution. So it was almost as if he made the amendment himself, even though it was really written and proposed and introduced in the 1700s. So yeah, it took over 200 years to ratify. So yeah, this is a very interesting when you think about it, the history of it, and how this one individual managed to do what is in the United States is almost politically impossible. Yeah, basically, it's an important amendment. Obviously, it's not life-changing, but it's good. It's a lot of constitutions have similar provisions around the world, so it was a good amendment. But it's really gone unnoticed, I think, in the public and really in litigation as well. It's really never been litigated. Yes, that's our constitutional law class, the longest class in the course. I'll see you in the next class where we'll discuss procedure.